Hi, today we're going to talk about the use of language in legal situations in the educational setting. I'm Dr. Katie Herbold, and I am faculty in graduate studies in education and a former many years teacher and administrator in public schools. The information I provide here is based on my experience and the training received during that time, and is not intended in any way to be legal advice. So I'm going to make sure that's clear up front. In the use of language in legal settings, I need to make you aware that language and words are used very precisely, with very specific meanings, with a lot of history and common knowledge amongst legal experts. So just as an exercise, usually when we're sitting down face-to-face in class, we might do an exercise like this. If you want to take out a pencil and paper and jot this down, give it some thought. This is a saying you're probably familiar with, and this is provided here without caps or any punctuation. But as an exercise, take a moment to put in some capitals and some punctuation. We do this as an exercise to see how many different meanings we can get. In graduate classes in the past, we've gotten 12, 13, 14 different varieties of this, of different meanings from these words in the same order. But here's three of the most common that we receive. You might have punctuated it this way. Woman, comma, without her man is nothing. And that is one way or one interpretation of these words. But taking the same words, you might have gotten this interpretation. Woman, without her, man is nothing. So the difference of the placement of a couple of commas can make an entirely different meaning to those words. Here's another one. Woman without, her man is nothing. And it can go on. And you can get a lot of different interpretations off of the same words. Now, what's happened over time is that through trial and error, a lot of different cases, trials, legal opinions have been written, which have helped to fine-tune and help to define the specificity of legal terms. Another thing to look at is this, and I wish there were a better way of doing this, but you can also take a look at this in person if you like. It comes off of www.planetperplex.com/en/item 363. So I'm going to hold this up for a minute. I don't think it'll work very well in this setting, but this is a picture that is primarily straight lines. But if you focus on that X in the center for just a moment, a series of circles may pop out at you. Again, some people will see it with simply straight lines, and others will see it with the circles in the picture as well. Same image, but different interpretations. So we need to be careful as we use language in the study and in our discussions of law. When I talk about the different registers of language, you may or not be familiar that there are different what we call registers of language. They are frozen or static, formal, consultative, casual, and intimate. And if we take kind of examples here. In an intimate setting, an intimate language is the language that happens within people who are very closely associated. For instance, lovers, or parents and children, or very close friends, people that you would use language with in a certain way that you wouldn't normally use just in general. If we use just talking about if a person were calling their dad, they might say, "Hey, yo, Pops," and that would be a very intimate kind of thing because, for instance, that person may not refer to their father that way in front of others as Pops. A casual way of calling your dad or greeting your dad might be, "Hey, hey, Dad," just very casually. If you were going to approach your father in a very, serious way, maybe you really wanted to have a serious talk, you might say something like, "Excuse me, Father," and so you can see the progression up the line. When you get into a more formal language register, that's when you get into something like "Dear Heavenly Father," which might lead into a spontaneous prayer that is of your own making. That would be a more formal. And when you get into the frozen or static register of language, it's going to be something like the Lord's Prayer, "Our Father who art in heaven," and on, which the language never changes. Another example of frozen language is, "I pledge allegiance to the flag of the United States of America." Always changes. The frozen register does not change very often, but as you've seen recently, attacks on the Pledge of Allegiance, for instance, with people who would like the "under God" removed from the Pledge of Allegiance, you can see that, for well over 200 years, that has not changed. And while it could change, it won't change often and it won't change much, but that is the nature of frozen or static language. So when we're talking about legal terminology, we're talking about language that's going to be used in the consultative or formal register at the very least. In some cases, it might even be frozen or static, as in the courtroom setting, "All rise." That's pretty much traditional and set and doesn't change much. So you're going to be in those higher registers. You're going to find too that when you're using registers, you can usually change one register and be okay, but if you take a drop and skip a register, and for instance in a consultative setting drop to intimate language, you're going to be totally inappropriate. So that's the reason why the study of this terminology is pretty important, and also that we understand that it is toward the higher end of the language registers, and it is used very purposefully, very specifically, and with prescribed meaning. The terms used in a legal setting have a long history, and over time they have come to have very specific meaning and a commonly understood meaning among legal practitioners. So let's talk about some of the specific terms. Legal definitions may be different than everyday language. Now, there are a lot of places that you can go to get the definition of a word. And you can go to Google, for instance, and go type in the search window, define, and whatever word you'd like defined, and you'll get many options for definitions. When you go in a dictionary, you're going to get different varieties of definitions. You want to be careful as you're looking up terminology for the law, that you do get the legal definition, because the legal definition can be different or slightly different than what is used in just everyday common language. For instance, the term reasonable. We say all the time, we're saying, well, that's reasonable. Sure, that's reasonable. And we have a common understanding in our everyday language of what reasonable is. In legal terms, that is a very precise definition that goes something like the test of reasonableness is an action that might be taken by most reasonable persons in a given situation. So when someone's looking to see, well, was that a reasonable action during a trial, they're really looking for a precise definition of commonly accepted way to measure reasonableness by a courtroom, by legal practitioners in a courtroom. Assault. Assault is a word that you hear all the time. And usually when people say assault, they immediately think of punches, of something very physical. It's commonly used that way, but in a legal setting, there are two terms very closely related, assault and battery. An assault is defined as a threat. So that's usually in a verbal context. So something to be aware of. Another word that has kind of a different meaning in everyday language as opposed to legal meaning is nuisance. We think of, a pesky fly as being a nuisance, or a student that keeps pestering us as being a nuisance, whereas the legal term nuisance tends to refer to something that could be or become a danger. For instance, a broken swing on the playground is considered a nuisance, and it is a nuisance because someone could come to harm because of the nuisance that is the broken swing. So that's a very specific and different definition than what we're going to have as your regular everyday term. So be careful when you're looking up definitions that you are getting legal definitions, not everyday common language definitions. There are several pairs of terms that kind of go together. I want to make you aware of the differences of those. We've already mentioned assault and battery. When you think of this, we talk about assault being a threat. I'm going to kick your butt. That is an assault. Did you touch the person? No. You gave a threat, and that person was assaulted verbally by you. Battery. You've often heard the term of a battered wife or battered woman or battered children. That comes from the physical abuse that a person receives from being battered. So assault is a verbal threat. Battery, more commonly, the physical attack. Assault and battery. Libel and liable, L-I-B-E-L, libel, and liable are two entirely different meaning words. They sound the same, but they have different meanings and different definitions. Libel is a derogatory statement about someone in print, whereas liable, along with liability, is being legally responsible. So there's difference there between libel and liable. And then as we go, libel and slander, or slander and libel. Slander is derogatory verbal comments stated about someone, and libel is L-I-B-E-L. Libel is when you make those same derogatory comments in writing. So there's a difference there, slander and libel. De facto and de jure. De jure. De facto and de jure, you're going to see this term used a lot, particularly when we talk about segregation. And de jure, think of it as forced segregation, and de facto segregation as segregation that just happens. It just happens. So let's say if you had de jure segregation, it would say that all black students have to attend this school. That is de jure segregation. On the other hand, if black students their families tend to live and move and buy homes in a certain area, then that is de facto segregation. That is just happened out of people's own choosing. They choose to be together, and the result is de facto segregation. They are not segregated by force, simply happened by where they've chosen to live. So that's a couple, and there is a good site to go to for some very clear, some very clear discussion on these terms. It is www.adversity.net/capital terms _ capital definitions / capital TERMS / capital segregation.htm. And that is a good source for finding a good discussion or a paper on the definition of those terms. There are some legal terms that are especially significant to educators. Tort immunity is a legal concept that we've been very blessed to be protected by. Now, things can change over time, and there's some belief that we may be losing some of our tort immunity. But as educators, here's what this means to us. Tort is an intentional harm done, and what it means is that we are immune to lawsuits based on our claiming or that we would cause intentional harm. So, for instance, if a child's on the playground playing, a teacher is on playground duty supervising the children, and a child falls off the monkey bars and breaks their arm, then the parents are going to be upset, obviously, and they may decide they want to sue. Well, they can sue because anyone can sue anyone else for anything at any time. But it's been in the past that if they do place that suit, the judge will look at it. He will look for negligence. If there is no negligence involved, then the educator, the practitioner is protected from the lawsuit, and the judge would dismiss the case. And so, no problem there. And that's one of the greatest blessings we have, because certainly when you're working with other people's children, or OPC, that you're going to, thank you Dr. Thompson on that, you're going to have you're going to have responsibility. Things will go wrong without anyone's ever wanting that to happen. But tort immunity is a huge protection that we have enjoyed. The conditions that you have to meet in order to be eligible for tort immunity are: one, that you are making a good faith effort to do your job properly, and two, that you are not being negligent, which we'll discuss more in a moment. Tort immunity does not apply at any time to a person driving a vehicle transporting school children. So please be aware of that. As you are responsible as the driver, you are the sole entity that has influence over what's happening with that vehicle at any given time. And therefore, if you are transporting children in a vehicle, any vehicle, even a school bus, you do not enjoy tort immunity. You can be held personally liable if an accident occurs. Another couple of terms are breach of duty and negligence. Let's talk about that playground example, for instance. If you had a playground situation where a teacher was assigned to do playground duty and forgot or got involved with other things and was not out on the playground at the time she was assigned or he was assigned for duty, the child gets hurt, then there is negligence involved because you were not, I'm sorry, I'm getting this all mixed up. I'm defining breach of duty. Breach of duty would be that you simply didn't show up for your duty. So you got involved with something else and were otherwise not on the playground. You would be committing breach of duty. You simply were not performing your duty as you were assigned. On the other hand, if you were on the playground, on duty, but rather than being in the place where children were or watching what the children were doing or actively moving toward problem areas, but choosing instead to stand under the shade tree and talk about, the world situation with your colleagues, not paying attention to the children, then you would be negligent. You would be there, but you would not be doing your job well. And so that would be negligence. You weren't performing your job in good faith. So again, those are very important. Due process is a legal concept that's extremely important to educators, and that is a child must always given, and in fact, educators are too, thank goodness, must be given due process. And due process is a very specific there are very specific steps involved in making sure that a person is given a fair chance. So in a due process, first and foremost, let's say something happens in the classroom and you're asking questions to try to find out what happened. And the first student you ask says, well, Johnny did it. And then if you were to immediately say, well, Johnny, then you have to stay after school, you haven't given Johnny due process because you've denied him the right to explain his side. And so that's one of the first steps of due process, is allowing the student, 1, to know what they're being accused of, 2, to explain their side, 3, to ask for evidence, 4, to provide witnesses, etc., etc., etc. So there's a number of very specific requirements for due process, and it's very important as educators that we always practice and use due process whenever we're dealing with a student who has an infraction. Another important concept is in loco parentis. And in loco parentis is Latin for basically standing in the place of parents. And what that means is, according to legal practice over centuries, I suppose, that when parents entrust their children to us during the day as students, that they're giving us permission to make decisions for their children in their place. And so this is a very important legal concept, which is very helpful for us as we go through our daily work. So in loco parentis, working or making decisions on behalf of the child in place of the parents. And there are, of course, limitations on that, but there are also many freedoms and responsibilities that go with that as well. There are some Latin terms that you're going to want to be familiar with. Some of them you probably already are. Bona fide. I love this term, and it always brings to mind the movie Oh Brother, Where Art Thou? And oh bona fide husband that he was not. So bona fide means you are the real thing. Bona fides means you have the credentials. So if you are a teacher, you have a license to teach, and you are in fact a teacher. A person who is teaching without the proper credentials is not bona fide. So you all, congratulations, are bona fide teachers. Certiorari. This is spelled a little bit differently. It's C-E-R-T-I-O-R-A-R-I. Certiorari is the means by which a case moves from a lower court to an upper court, but not through appeal. For instance, let's say that there is an abortion case that is presented in a lower court. That court could begin to try it, but recognizing the significance, the possible outcome of the court, it could be that a higher court, like the Supreme Court, might see that or be aware or be made aware of that case and simply write a writ of certiorari to the lower court saying, this is a case that has the potential of such magnitude and importance to, all the whole nation. We are bringing it up into the Supreme Court. And so that is not by appeal. That is not having the case tried in the lower court and then appealing the decision. It's different than that. It's simply by the higher court reaching down and declaring that they're going to move that case from the lower court to the docket of the higher court. Writ of certiorari. Quid pro quo is used fairly commonly, particularly in the negotiating phase between prosecutors and defense attorneys. Quid pro quo generally means this for that. It is a trade. If you'll do this for us, then we'll do that for you. If you'll give us the name of the informant, we'll reduce the charge or the sentence or whatever's appropriate at that phase. So quid pro quo simply means this for that. You also might hear that used in cases of sexual harassment, where it's like, well, if you will do me this sexual favor, then I will recommend you for a promotion. It can also be used in that way. Prima facie is at face value. For instance, let's say you had a slander or libel case where someone is saying, well, so-and-so is fat. Well, if at face value the person is definitely obese, then it's no longer slander or libel. It is, in truth, it is fact. So prima facie means just at face value. De facto and de jure we talked about a little bit, and de jure meaning forced and de facto meaning just happens. And we've also talked about in loco parentis, acting in place of the parent. So that's a brief overview of the terminology that's going to be important and some highlights. I hope this is helpful to you, and I appreciate your time in listening.